Good afternoon and welcome to the Appellate Division, First Department. I will begin with the call of the calendar. Counsel, please pay attention for your name. People v. Brandon Garcia. Ms. Wu.
Yes, Your Honor, Victorian Wu for Appellant Brandon Garcia.
Good afternoon. You have 5. Mr. Commendoria.
Good afternoon, Your Honor. John Commendoria for the Office of the Bronx County District Attorney.
Good afternoon, sir. You have 5 minutes.
Thank you.
Cortez versus Bray is submitted. Nation Star Mortgage versus Torres. Mr. Miller.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4 and 1.
Good afternoon.
For
Apologies.
Not a problem. Counsel for respondent.
Good afternoon. This is Jamie Katz Sussner with the firm of Sills Cummis on behalf of respondent.
Good afternoon. You've been granted 5 minutes.
Thank you.
Utopia Heart versus Gramercy Cardiac.
Good afternoon, Your Honor. Manmohan Bakshi for Utopia Heart Care.
Okay. You've been granted 3 and 1.
Yes, Your Honor.
And respondent, Mr. Maglieri?
It's, Your Honor, thank you. It's John Malieri for
Malieri.
Cardiac. Thank you.
Okay. Thank you, and sorry for the mispronunciation. You've been granted 4 minutes.
Thank you.
Scott versus Logan Bus Company. Ms. Rosen.
Good morning, Your Honors. Jillian Rosen, the plaintiff appellant.
How are you?
Good.
You've been granted 7 and 3.
Thank you so much.
Ms. Her Solomon for respondent.
Good afternoon, Your Honor.
Good afternoon. You two have been granted 7 and 3.
Thank you.
People versus Martinez is submitted. DeShane versus Tricon Construction is submitted. 388 Realty Owner versus AmTrust International. Mr. Gershwire?
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 4 and 1.
Thank you.
Mr. Sands for respondent?
Good afternoon, Your Honor.
Good afternoon. You've been granted 4 minutes.
Thank
Lynch versus City of New York. Mr. Smith?
Yes, Your Honor, I'm here.
Good afternoon. You've been granted 10 and 2.
Thank you.
Mr. Moore for respondent?
Yes, Your Honor. Good afternoon.
Good afternoon. You've been granted 10 minutes.
Thank you, Your Honor.
The cases 10, 11, and 12 on the calendar, Universal Construction versus NYCHA. As I said, pre-calendar call, now that I realize that the same counsel is arguing on all 3 cases, I am revisiting the time allotted, and worry not that the time is for you, not for the court. So if the court still has additional questions, we can continue to ask questions. Okay, so appellant, please help me with the pronunciation of your name, sir.
Yes, ma'am. Gil Namias for the New York City Housing Authority.
Mr. Nahamias, you've been granted 7 and 3, and as I said, if the court has more questions, we will continue, okay? Mr. Marco.
Thank you, Your Honor.
You're welcome. Mr.
Yes,
Marco,
Your Honor.
good afternoon.
Yes, can you hear me?
I'm
Good
granting
afternoon.
you 8 minutes, and again, if the court has additional questions, we will keep going, okay?
Your Honor, may I say something? It may make more sense to argue the middle appeal first, with it ending in 04313, as that one would encompass more of the issues, I believe.
You can choose to argue as you wish, okay? Based on our review of this case, the issues, the ultimate legal issues are the same. It's just the factual circumstances that are different. So you can choose to do your argument as you wish, okay? Next case, Segali versus Carrega is submitted. U.S. Bank versus Bakhtor.
Good afternoon. Sure. Good afternoon, Your Honor. Joseph Froelich from Lock Lord for Appellant U.S. Bank.
Good afternoon, Mr. Froelich. You have 4 minutes and respondent requested none. People versus Williams is submitted. 10-2 Trees versus Mahoney is submitted. Cuenca versus Beach 65 is submitted, and Getz Fitzpatrick versus OTR Media Group is submitted. First case on the calendar, People versus Brandon Garcia. Mr. Wu.
Good afternoon, Your Honors. Can you hear me?
I can hear you, can't see you yet, but.
I think my camera should be on.
Do you see yourself in the corner?
I do.
All right, so it'll come up in short order. You may proceed.
Thank you. Good afternoon, Your Honors. Victorian Wu, Office of the Appellate Defender, on behalf of Brandon Garcia. The record in this case supports a modest reduction of 2 years in Mr. Garcia's sentence. A new sentence of 12 years would still be very lengthy and would be sufficient to satisfy the goals of sentencing. Importantly, it would also be commensurate with Mr. Garcia's individual circumstances. Mr. Garcia had no prior record whatsoever. This was his first arrest and conviction. The record,
but he started at the top of the heap with this first conviction.
Your Honor, it is unfortunate that the incident was tragic and serious. There's no doubt as to that. The question is, in light of his lack of any prior record and other mitigating circumstances here, whether a sentence that is slightly less than the sentence imposed would still be sufficient to serve the purposes of sentencing. And I think the answer to that question is undoubtedly yes.
Why should we undercut a plea negotiation that was almost 3 years in the making? And I mean, this is, to say that this was tragic is an understatement here. They killed a young man for no good reason.
Your Honor, yes, you're absolutely correct. And I think both defense counsel and Mr. Garcia at sentencing, expressed their regret, their sorrow, their deep remorse for the incident here. Again, the question is whether a modest reduction in the sentence would nonetheless result in a sentence that is sufficiently severe and sufficiently long. And for someone like Mr. Garcia, who had no prior trouble with the law, this was clearly an isolated incident that was out of his character. And the other important thing is that he was only 21 years old at the time. And the scientific research over the decades have shown that the part of the brain that manages, behavior control and impulse management continues to develop into the early 20s. And so some of the insights that apply to juvenile defendants also apply to young adults. And that obviously does not justify.
Mr. Wu, yeah. I take a little bit of with your statement about that they were so remorseful. I mean, I think there was some kind of question. Both he and his brother, Mr. Garcia, and his brother were involved in this incident. And it's my understanding that he and his brother fled to Puerto Rico and had to be apprehended and extradited back to New York after that incident. So they tried to flee, and they did flee and were extradited. So I'm not sure, even in the courtroom, I mean, I'm not sure that his remorse went out as much to the victim, who was also a father and a son and a grandson, as much as it did to his own brother.
Well, Your Honor, I think the fact that he did flee to Puerto Rico is a sign of his immaturity. He got into a situation that he had never been in before. He had never had trouble with the law. He was most likely very scared, and he may have been acting to in a way to protect his younger brother, as you know, who was incident. And importantly, at this time of sentencing, I would disagree that Mr. Garcia did not apologize to the decedent's family. I mean, he said that he was sorry to the brother that he knew for a very long time. I think the decedent was his friend, and by saying that he was sorry to the brother that he knew for a very long time, I think he conveyed the idea that he treated the decedent as family and thereby extended his apology to the victim's family in the courtroom at that time. And defense counsel also, made clear at sentencing that Mr. Garcia had apologized to the victim's family, had conveyed his deep remorse. So I think the record shows that Mr. Garcia has fully accepted responsibility for his conduct.
Okay, thank you. You have some time in rebuttal.
Thank you.
Okay, Mr. Commendoria, you have 5 minutes.
Thank you, Your Honor. Good afternoon, and may it please the court, John Commendoria for the office of Darcel D. Clark. Your Honors, the defendant killed Daniel Pena by stabbing him 3 times so forcefully that the knife blade broke from the knife and was lodged in the victim's chest. After which, when defendant was extradited back from Puerto Rico and had extensive plea negotiations that involved not only him but his co-defendant brother, he validly waived his right to appeal, pled guilty to first-degree manslaughter, and received just 14 years with 5 years post-release supervision. As Your Honors have indicated in your questions to my adversary, he didn't accept responsibility by fleeing to Puerto Rico, and this was a very brutal and severe case where someone was killed. That and the fact that he negotiated for this and even swore that this was a reasonably good result, all factor against reducing a sentence and support affirming this judgment. And if Your Honors have no questions, the people ask that you affirm the judgment.
Thank you so much. Mr. Wu, you have 1 minute.
Yes, Your Honor, just very quickly, I think respondent emphasizes that this was a negotiated plea, and at the plea proceeding, Mr. Garcia, was asked, is this a reasonably good result? There's no doubt that he answered that question in the affirmative. But if you look at the plea minutes, it also shows that Mr. Garcia did not actually get the sentence that he was asking for, which was a sentence of 13 years, just 1 year less than the sentence that was promised and later imposed. So again, we're asking for a modest reduction in Mr. Garcia.
So he asked for 13 at sentence and now he wants 12?
Yes, we're asking for a modest reduction in Mr. Garcia's sentence because of his lack of prior record, his young age, and the fact that
don't you think that 11 years off the maximum was already a consideration that was given to him and granted to him by the court below in agreeing to a 14-year sentence?
There's no doubt that this was a favorable plea for Mr. Garcia, and again, we're asking.
And the fact that it was because it was his first arrest that the court gave him 11 years off the max.
Yes, Your Honor.
That factor that he was a first arrest individual has already been taken into consideration, no?
Right, and this court has the plenary power to reduce a sentence as a matter of interest of justice, based on the circumstances that it finds. I think, again, the record shows that a sentence that is slightly less than what was imposed would nonetheless be sufficiently lengthy to reflect the circumstances at hand, including the severity of the incident, Mr. Garcia's lack of any prior record, his young age, and the family support that he has. So for all those reasons, I would ask that this court reduce Mr. Garcia's sentence. Thank you.
Thank you so much. Have a good afternoon. Nation Star Mortgage versus Torres. Mr. Miller, you have 4 minutes.
Good afternoon, Your Honors. The primary question on this appeal involves deciding whether the Court of Appeals and the Supreme Court of the United States mean what they have often said about standing. It is a threshold determination, an aspect of justiciability, which must be considered at the outset of any litigation. As the Court of Appeals said in the Saratoga County Chamber of Commerce case, if standing is denied, the pathway to the courthouse is blocked.
Well, let me, Mr. Miller, may I ask you a question? The way I read the briefs, it appeared to me that your client did not actually challenge the court's finding that held that both the note and the mortgage, that the plaintiff held both the note and the mortgage at the time that it commenced the action. And therefore, it doesn't appear to dispute that there are, that there was standing to at least commence this action. Am I wrong about that? Do you dispute that they held the note mortgage at the time they commenced this action?
I do dispute. My client definitely raised standing as an affirmative defense.
I understand that.
That wasn't the question.
But I'm asking about what, in terms of what is it that you're claiming? Do you claim that the bank did not have the note and mortgage at the time they commenced it? Are you saying that they weren't able to establish that your client had actually defaulted in the payments on the mortgage? What was the issue in standing that really is your thing?
Well, first of all, my client, it's the plaintiff's burden to prove standing. My client wouldn't have the firsthand knowledge. If we had discovery of the issue, maybe. The IAS court said the plaintiff didn't have lack of standing. My client responded when the plaintiff attempted to prove his standing. But the plaintiff didn't even make a prima facie case on standing. That's what the IAS court found. They did not attach the note to the complaint. They submitted an affidavit of Rebecca Wallace, who had no firsthand knowledge and did not attach the business records. And then, even on top, I'm sorry.
Mr. Miller,
Yeah.
Mr. Miller, this is Justice Shulman. My review of the record shows that attached to the Wallace affidavit as Exhibit 1-2 was the copy of the note and 2 was the copy of the mortgage. So the pivotal documents were there, not separate from a tacit admission on the part of Mr. Plott when he accepted the referee deed where he acknowledged the existence of the mortgage. So I think I take issue with your point that was not part of the complaint. I think if I understand Judge Gonzalez's decision, the issue is whether there were business records to establish the assignment, the transfer from City Mortgage to Nation Star, the mortgage and note. We have Ms. Wallace saying, yes, Mr. Cooper on behalf of Nation Star has the original note as of April 2012. The question is, how do we establish how it came from City Mortgage to Nation Star? And I think it was on that basis that the court held that standing or that defensive standing appeared to remain, notwithstanding that the court dismissed all the other affirmative defenses and counterclaims. You don't agree with that analysis?
Well, I certainly agree that the IAS court found that there had been no proof that at the time the action was commenced, which is when we look at standing, the Nation Star had not shown that it, in fact, had the note. Now, the fact that an affidavit on summary judgment a few years later, at that time they had the note, doesn't show the standing at the beginning of the action. But there's something else in the record, Your Honor, and we didn't brief these points, but I think you all need to know about this. In the record, if you look at the notice of default,
if it's not in the record, counsel, you can't argue it.
It is in the record. I'm sorry. It is in the record. It wasn't briefed because we're not challenging the IAS court's determination about standing. But if you look in the record, and I'll find the page if Your Honors want me to, there's a default letter in October of 2012, after the April 12, 2012 date of Ms. Wallace, which says that Federal National Mortgage Association is the creditor right now. So even on the very submissions that the plaintiff made, there is a fact as to whether or not Nation Star was in possession of the note at the time it commenced the action. It may have been in possession of the note when it moved for summary judgment a few years later, but that's not what standing's about.
Okay, you'll have time on rebuttal. Ms. Katz-Sussner, you have 5 minutes.
Thank you very much, Your Honors. May it please the court, Jamie Katz-Sussner for respondent. This is interesting because the reality is standing is an issue that while it has become front and center on appeal, it really wasn't the crux of the basis for the appeal. The IAS court, as Your Honors were correctly discussing with my adversary, the IAS court really narrowed it down to a single issue. You know, really the issue is about the transfer of the loan to Nation Star. The court otherwise found that there was standing. And as counsel just admitted, there's not really a material challenge to that core finding. The fact that the court denied summary judgment and basically is allowing the parties to further flesh out the issue at the time of trial allows more than adequate opportunity for the issue to be resolved conclusively. It doesn't mean that the court didn't have jurisdiction to issue the rulings that it did.
Well,
Certainly-
if what I don't understand is if in fact the court ultimately finds that there is no standing, since there is a standing issue that Judge Gonzalez found, how do we go past that? Shouldn't standing be the first thing that is determined before we start getting into the substance of the other 20-some affirmative defenses?
Well, Your Honor, no. The answer is no. Of course, standing is a threshold issue. There's no question about that. But the court didn't find that there was not standing. It merely found that there was a factual issue. So when considering
factual issue, wait. No, it wasn't a factual issue as to whether or not the plaintiff had standing because there was a question as to the transfer of the note. Isn't that standing?
It is standing, Your Honor, but the fact that the court has invited the parties to submit additional proofs to demonstrate a fact that's in dispute, but there's really nothing at this point to suggest that there's not standing. The court exercised its discretion not to dismiss the pleading, but to deny summary judgment to allow this discrete issue to be resolved. The fact that the court was considering standing together with 24 other affirmative defenses and had the opportunity to rid from the record, to resolve unsubstantiated defenses at the same time that it was considering standing, there's absolutely nothing procedurally improper about the court exercising its discretion to resolve certain issues, even though it found that more is required as to others. If you look at the cases that have been cited by the parties, and specifically those cited by Mr. Plotch, almost uniformly, there are cases in which summary judgment was denied, but the action was not dismissed. The reason being that the trial court found that there should be, that equity required an opportunity for standing to be further developed, that perhaps there would have to be a trial, perhaps there will need to be witness testimony at a trial concerning standing and the transfer of the loan to NationStar, perhaps. Or perhaps there might be another summary judgment motion to resolve the issue. But ultimately, the fact that the court elected to resolve certain issues that it found based upon the record before it had been clearly resolved. Those 24 additional affirmative defenses that the court found to be unsubstantiated, the fact that it resolved them while carving out an issue that requires further litigation is an entirely proper exercise of the court's discretion. If there was to be a different result, if every time a litigant alleged standing as an affirmative defense, it meant that no other defenses could be considered, the courts would come to a halt. It doesn't make sense. The court has the discretion to practically and reasonably, using common sense, consider the record before it and make decisions that it's capable of making at the time and reserve for later those that it does not.
This is Judge Schulman. So it is your position that essentially the note and mortgage itself is prima facie evidence of an existence of a debt, so to speak. There is no issue that there was a default in payment. There was no issue that we are dealing with the property in issue, even though one particular document has oval rather than avenue. I mean, I don't have to go through all of them. So essentially, we're really left with one issue. And otherwise, you'd be able to go to foreclosure, judgment, and sale. It would be, can we prove through business records or through testimony the transfer from City Mortgage to NationStar, even though NationStar established that it was and is in possession of the original note and mortgage, correct?
That's exactly right, Your Honor. I couldn't have said it better. It's
a one issue case that's left, really.
That's exactly right, Your Honor. And that's an appropriate and very sensible way for the trial court to resolve the issues that were in front of it. We respectfully believe that the court's order should be affirmed.
Okay, thank you.
Thank you, Your Honors.
All right, counsel, you have 1 minute.
First of all, there are many issues on the substance that we've briefed, and those are before Your Honor in the briefs. But there's a danger here that's being missed. There's a reason why neither I or my learned opposing counsel could find cases where summary judgment was denied on standing, and then the substantive issues were discussed. The danger is advisory opinions.
Can you tell me which, sir, can you tell me which of the affirmative defenses or counterclaims that were dismissed would be impacted by the decision on standing?
We challenged.
How does standing make a difference in any of the matters that were dismissed?
No, if the plaintiff got past the issue of standing, there are other substantive issues where we attack the validity of the mortgage.
Counsel, you're answering my question in reverse. So it would be helpful if you actually answered the question asked.
I'm sorry, Your Honor, I didn't hear the last thing you said because I didn't hear the last thing you said, Your Honor.
I said it would be helpful if you answered the actual questions that you were asked.
Well, I believe.
And my question was, what of the affirmative defenses that were dismissed would be impacted by the remaining issue of standing?
Well, the standing determination, I don't think it impacts the other issues except perhaps the prima facie case, to the extent the Wallace affidavit tries to show a default and she had no personal knowledge, and if the business record she attached to her affidavit, if they're relying on that affidavit for standing, then it does impact that. But the danger of advisory opinions is real. Your Honor, if you should decide on one of the substantive issues that Mr. Plotch was correct, the mortgage was invalid, or that there was no proper proof of a default, and then if there's no standing, what happens when the next plaintiff brings the case, saying, wait a minute, I've got the note, and all that?
Thank you.
We can't.
You're out of time, sir. Thank you so much. Utopia, Hart versus Gramercy Cardiac.
Good afternoon, Your Honors. Can you hear me?
Good afternoon. Mr. Bakshi, you have 3 minutes.
Thank you, Your Honor. Defendant's transactional counsel drafted the agreement and insisted upon representing that Dr. Rentrop was the sole shareholder, officer, and director of the defendant. Paragraph 5 of the complaint alleges that the agreement was signed and at all times thereafter, Dr. Rentrop was its sole shareholder, officer, and director. This allegation was admitted by the defendant in their answer. The defendant, the professional corporation, was formed by Dr. Rentrop for the practice of cardiology. It is subject to BCL 1503, which mandates that all officers must be New York State licensed physicians. Any termination of the agreement was drafted by defendant's counsel to have personal consequences upon Dr. Rentrop and Dr. Shivaram under paragraph 10, which is why the individuals signed the agreement on behalf of their respective entities as well as themselves personally. Ms. Gill was merely a clerk and not a physician. She never was and cannot legally be an officer of the defendant. An act as serious as a complete shutdown of a medical office and termination of a lease would have significant consequences upon the patients, the hospitals.
Well, Mr. Bakshi, may I ask you a question?
Yes.
You're referring to Ms. Gill's email of January 11th, 2016, I believe, that was sent to your clients. And about 6 weeks later, on February 23rd, of 2016, Dr. Shivaram wrote back to Ms. Gill and seemed to acknowledge, as far as I read it, your written notice was received and your responsibility to pay only goes until April 9th, 2016. So it seems that your client accepted the 90-day notice of termination. How can you now say, oh, no, that wasn't a 90-day notice of termination?
Your Honor.
Bound by what your client wrote?
Your Honor, those documents are inadmissible as hearsay. Dr. Rentrop was not involved in these transactions. He does not allege in his affidavit that he had firsthand knowledge of these underlying actions.
But Dr. Shivaram wrote this letter. He
Yeah,
stated
the
that
documents are inadmissible as hearsay.
No, we have accepted emails as evidence that is acceptable for summary judgment motions for quite some time now, counsel.
Your Honor, only if they established a business records exception. Dr.
So
Renfro
if
did
we
write the
disagree
email.
with you on this point, then you lose. Is that right?
I'm sorry, Your Honor?
If we disagree with you on this point, whether this email is sufficient in our minds, then you lose.
No, that is not correct, Your Honor, because
Really?
even if that was established as a business record, it is not tantamount to a termination. There needed to be a termination by Dr. Rentrop and an acceptance of that termination by Dr. Shivaram. There never was a formal termination. A verbal discussion with a clerk followed up by an email is not a termination. It is
But
not
this-
as if
I'm referring to, I mean, you don't seem to be addressing, I'm referring to a letter, not even an email, a letter from Dr. Shivaram saying that that we received your notice of January 11th, which was done via email, and therefore your responsibility to pay rent goes until April 9th, 2016. So how, I just don't understand how that letter on the letterhead of Utopia Healthcare written by Dr. Shivaram is not admissible as hearsay. I mean, it's Dr. Shivaram saying we accept it.
I understand that, Your Honor, but my position is that is not tantamount to a termination of the agreement, which is now going to bind Dr. Rentrop personally in his
all right.
capacity.
Thank you. You have 1 minute on rebuttal.
Thank you, Your Honor.
Mr. Mallory?
You're on mute, Mr.
I may have
Malieri.
messed up your name again, and I am sorry if I have.
Thank you very much. John Malieri, may it please the court. Your Honor, this case really is the Zuckerman case, the seminal Zuckerman case, because what we have is competent evidence from Gramercy and no evidence from Utopia. The verified complaint is in fact not verified, Your Honor, by the client, but rather by the attorney, and Utopia has put in no evidence other than an attorney affirmation on both its moving papers and its opposition, even after we raised our prima facie case for entitlement to summary judgment. There's not even an opposition affirmation from or affidavit from Mr. Bakshi's client. So the court really is only bound to accept the evidence that Gramercy submitted. And that evidence, as Justice Kapnick has pointed out, includes an admission by Utopia, and the trial court, and I quote, says, defendant thus demonstrates prima facie it terminated the contract. There's simply no reason to upset that decision. In fact, there'd be no ground. Our only error that we submit to this court is that after that sentence, the trial court did not grant us summary judgment on the issue of whether the agreement was terminated. There's simply no evidence in opposition. We also have sought summary judgment on the amount of damages because the letter recites that $14,950 is due of remaining termination fee, that 3-month period. The trial court says that that number doesn't equal 3 months worth of termination fee, but this court does not need to indulge that speculation given that Utopia failed to submit any cognizable evidence to the contrary. And I'll also say, if I could, that Mr. Bakshi confuses the idea of business records and personal knowledge. Business records are used when there is a custodian of many, many business records and they testify, here's where I keep the records in the ordinary course of business. Here, Dr. Rentrop says, I asked Gil to send the letter. She's the CFO of the company, by the way. And Rentrop is copied on the email. His name is there. He doesn't need a business record certification. He has personal knowledge. He's there on the email. So, Your Honor,
Counsel, this is Justice Kennedy, and I want to go back to the issue with respect to the damages, because you were saying that the court made a mistake. But my question is, what evidence did you present regarding the amount owed? Because really what you're doing is just relying on the January 2016 letter. But what evidence did you set forth with respect to the amounts owed?
Yes, thank you, Your Honor. And I think we've briefed it in the papers, but we're relying on an admission. It seems that the parties go back and forth about what amount was partially paid of the termination fee. And I acknowledge that it's a math question as to why they got to $14,950. But the question for the court is, does this court have any basis for evidence submitted in contravention of the prima facie case that we've submitted? Here's an admission against evidence under the evidentiary rules. Here's an admission. They submit nothing in response.
So your letter, Mr. Malieri, says, not your letter, but
right.
Dr. Shavaram's letter said, please submit a check in the amount of $14,950 to fulfill the terms of the lease. You're saying they never said, oh, no, that's the wrong amount. You know, that's really a problem. I mean, that was the only number that ever came out. And so we should be able to rely on this, even though there's been nothing else put in on that issue.
And Your Honor, yes, not only did they not say something then, but more importantly, they didn't say something now on this motion. There's no evidence. We moved for summary judgment. We've made a prima facie case according to the trial court. And in opposition, Utopia did not put in one iota of evidence that says the amount is actually something different. My point is just, this is Zuckerman. We have a hearsay attorney action. That's it.
Thank you.
Thank you, Your Honors.
Mr. Bakshi?
Thank you, Your Honors. Your Honors, first of all, our complaint sets forth a cause of action for legal fees. So irrespective of what they are alleging that they owe, there is a cause of action for legal fees. So we are entitled to recover our legal fees. Secondly, with reference to Dr. Shivaram's notice, there is, they didn't vacate pursuant to that notice. They stayed in occupancy. So we're not limited to that. They didn't pay that amount, so we're not limited to that. Our damages continued subsequent to that. So this is a number that needs to be established. It needs to be established through proof, which was not presented by the defendant.
Thank you.
Okay. Thank you.
Scott versus Logan Bus Company. Ms. Rosen. And if everyone who is on this call and is not speaking could please mute their mic, that would be helpful. Ms. Rosen?
Yes, good afternoon, Your Honors.
Good afternoon. You have 7 minutes.
Okay, thank you. Your Honors, in this case, given the jury's finding that the plaintiff sustained a significant limitation under 5102 and had awarded the plaintiff $250 in future medical expenses, it's our position that the failure to award any damages for future pain and suffering and past and future lost earnings is against the weight of the evidence and inadequate. We're not taking
obviously, Ms. Rosen, you can't really argue inconsistency because that would have the trial attorney would have had to say something about that while the jury was still there.
Yes, that's not preserved, and under Barry against Manglass, we cannot take that approach. But it is against the weight of the credible evidence, and it is inadequate for the following reasons. So we have 3 very serious injuries. We have a rotator cuff that was torn totally from the bone, and Dr. Haar, who's the surgeon, the shoulder surgeon, testified that this is the worst possible rotator cuff surgery you could have. It's a full thickness rotator cuff tear. His shoulder will never be the same. It's torn off the bone. It's catastrophic, and he had surgery. And Dr. Sobel, who is another orthopedist, testified that his pain is disabling and permanent, and that he has disc herniations. Dr. Brisson, who is a spine specialist, saw plaintiff, and 4 years after the accident recommended a cervical discectomy and fusion on C3, C4. So his shoulder surgery and his cervical spine is there's clearly evidence that there's future damages.
Can I ask you a question before I forget, Ms. Rosen? The defendant, I think, presented testimony that there were ER records of the plaintiffs that indicated that there had been a prior shoulder injury that the plaintiff had not brought to the attention of Dr. Haar before the surgery. And Dr. Haar said something along the lines of, well, if I knew that, maybe I would have evaluated it somewhat differently. And that was why the shoulder injury, there was some question left to that. Was that what happened?
Well, what happened was the plaintiff testified that he did not have any prior shoulder injuries. And then on cross-examination, Dr. Haar did testify on cross-examination that he wasn't aware of that, and that even if that there is no doubt in his mind that this was a tear by the nature of the trauma and the nature of it being pulled from the bone, and that what he said actually was that had I known that, we may have attributed that prior injury to something other than the full thickness tear that I am attributing to this accident. And he was a surgeon inside the shoulder. So he did testify and acknowledge that on cross-examination, that had he known that, he may have attributed to whatever potential prior injury he had, which the plaintiff said that he didn't have a prior injury, that there was no doubt that this particular, and also as we know from McDuffie, this case in this court, McDuffie, that you could have a pre-existing injury or degenerative condition and a traumatic injury in the same film and in the same body part. But that's how Dr. Haar addressed that. And Dr. Sobel also testified that there's no question in my mind that this was as a result of the trauma. So we have Dr. Haar, we have Dr. Sobel, and we have Dr. Brisson. And all of these doctors have testified this is permanent, and that his shoulder will never be the same, and he will be permanently injured or damaged and have pain in the future. Okay,
didn't the jury not find a permanent injury? They found a significant limitation, but not a permanent injury. Am I correct?
Yes, you are. But as you know, under Sicilian against McAdams, just because you find a significant limitation, it doesn't mean that the injury isn't permanent. So if you have a permanent consequential limitation, which they did not find, it has to be permanent. But a significant limitation, it's not mutually exclusive. It doesn't mean it's not permanent. And his own physicians, his treating physicians, testified that not only was it permanent, but it was devastating, and his shoulder will never be the same again. With respect to the, I think what the jury did is either underestimated or underrated the significance of the traumatic brain injury. And this is something that, I mean, as we see this on soccer fields and everywhere with concussions, post-concussion syndromes, he had a very, very, very serious traumatic brain injury that Dr. Cicero, his current treating neuropsychologist, testified that he would have cognitive deficits that would prevent him from working for the rest of his life in the same capacity, and that he has problem processing information, memory, functioning as he had done as a private equity manager, and that he's going to need ongoing cognitive remedial care for the rest of his life. So we have Dr. Cicero, in addition, talking about his traumatic brain injury, which has across the board caused a significant diminution in his loss of earnings, which also was testified by his tax returns. It shows a precipitous drop from 2013 when the accident occurred to 2016, which was the year before the trial. And at trial,
and the jury found no past or future lost earnings.
Correct.
Am I correct?
Yes, and at the time of the trial, he had not earned any money in a year and a half. But in 2016, the year prior, he had earned maybe a third of what he had earned previously. So,
Ms. Rosen, this is Justice Kennedy. I just want to go back to the issue of the lost earnings.
Sure.
Now, the issue of the lost earnings, that was only based upon the TBI, the traumatic brain injury, correct?
Correct. Yes.
And the only objective test that we have is the MRI, which indicated that the results were normal. There is no other objective test, correct?
For the traumatic brain injury?
Yes, there was an MRI that said it was normal.
Well, no, Your Honor, I disagree, Your Honor, respectfully, because Dr. Cicero had done many, and Dr. Schneider also, who's a neurologist, a treating neurologist, had done many tests, a battery of tests, and found that he had cognitive deficits in the tests that she was doing. She had performed, I think it was, she treated him 127 times in three years, and over the course of that time had done numerous cognitive tests regarding memory and processing. And one thing I'd like to point out that is particularly devastating to the defendant is that their own doctor, Dr. Erlinger, who performed, he's a neuropsychologist who performed a battery of tests on the plaintiff. He testified at 1168 to 1169 of the record that the plaintiff failed the test, but he blames the plaintiff on exaggerating his symptoms. He actually failed every test that was given. The defendant failed the test. The plaintiff failed defendant's own test. So
I want to go back to the TBI, because certainly Dr. Snyder found he ordered the brain MRI and that was normal, correct?
Correct.
Okay. And then also he was referred for cognitive rehab, which the plaintiff did not do, correct?
Yeah, well, the plaintiff did cognitive rehab with Dr. Cicero after he saw Dr. Schneider. And I just want to point out, Justice Kennedy, one thing, that even though the MRI is normal, Dr. Chavant, who, by the way, is a board, she is a vocational rehab expert, but she's also a neurologist and a psychiatrist. So she comes at it from a medical aspect. She testified at 741 to 742 of the record that you can have a situation with TBIs where somebody presents normally, but they have processing issues and they have problems with their instrumental activities of daily life, social dysfunction, cognitive functioning, and this is in 741 to 742 of the record. And she testified as follows: because you could have patients who have traumatic brain injury who don't have any impairment of their basic activities of daily living. They can dress themselves, they can walk and talk, but their instrumental activities of daily living is where you see this dysfunction. And this is what we've seen here with Mr. Scott. He has some difficulty with cognitive functioning. This keeps him from going back to what his previous baseline is, and he'll never return.
Was there any testimony by any of the experts that explains why they opine that the plaintiff has a traumatic brain injury, yet there is no indication of it on an MRI? Do they explain why that is possible? Why, if indeed the doctor is correct that the plaintiff is suffering with a traumatic brain injury, does the doctor explain why that is not evidenced by the MRI, or is there another diagnostic test that can be taken that would show evidence of TBI?
Well, aside from Dr. Chavant testifying that the TBI manifestations aren't necessarily out, they may not come up on a diagnostic scan like an MRI. It is shown more in the daily, in his daily activities and his ability to, whether it's memory or processing, it's on the tests that were provided and given to him during the treatment. She's still treating him, or I shouldn't say now, it's towards the record. At the time of the trial, Dr. Cicero was still treating the plaintiff and testified that he still currently had issues with memory and processing and basic tasks, which aren't so basic when it's every day of your life and things that you used to do before. So I'm not so sure, and it may be in the big record that's here, that there was a question and answer with regard to, well, if it's not in the MRI, how could you state that to a reasonable degree of certainty? But for sure, there's testimony from Dr. Cicero and Chavant that these manifestations of traumatic brain injury isn't just about what comes up in a diagnostic test. Do I have any time left?
Thank you. You'll have time on rebuttal because we've gone way past your 7 minutes.
Okay.
All right.
Yep.
Ms. Herr-Solomon, you have 7 minutes.
Good afternoon, Your Honors. Catherine Herr-Solomon on behalf of the defendants, respondents, appellants. The overarching problem with plaintiff's appeal is that it ignores the jury's findings. The jury and the trial court heard all of the evidence. The trial court denied.
Yes, but this court has recently held in Palke that where a jury awards future medical expenses, that it is a material deviation to not award future pain and suffering? Why should we deviate from our own precedent?
In this case, the evidence, that determination by the jury can be reconciled with a reasonable view of the evidence. The jury found that the plaintiff did not sustain a permanent injury. So that explains why they awarded past pain and suffering and no future pain and suffering.
But they awarded future medical expenses. So obviously they thought there was something sufficiently wrong with him that would continue to be wrong with him into the future that would require medical treatment.
Not on this record, not necessarily. Because if you look,
you have an orthopedist who says his shoulder will never be the same again, and that it is not functioning anywhere the way it used to. And I don't understand that statement connected with that evidence.
If you look at the plaintiff's experts' projections in the life care plan, some of them involve monitoring and wellness care and costs that he would incur without necessarily experiencing pain. So and the jury obviously rejected most
suffering is not just pain, right? You can have suffering without pain, no?
You're talking like loss of enjoyment of life. I mean, it seems to me that there is a lot of testimony in the record about his not being able to do many of the things that he used to do that were part of his life. And that goes into, I think that's what Judge Manzanet, if I misspoke, I apologize. But I think that's part of what she was thinking about, that you know, pain and suffering is a very inclusive category, as we know.
Yeah, agreed, except on this record, plaintiff never testified that he was in pain. If you look at his testimony,
counsel, you keep on ignoring the and suffering part, and that is compensable too. So
right,
if you are a high-level private equity person before an accident, and then you go from that to barely functioning, not having control of your memory, and not being able to work, that seems to me to be part of a lack of quality of life and suffering.
But that's viewing the facts in the light most favorable to the plaintiff. If you look at
who should we view them in light of?
Well, the defense, that's a jury finding that was in favor of the defense. The jury's determination to not make an award for any lost earnings, past or future, can only be interpreted to mean that they did not believe plaintiff. They did not believe all of his claims, particularly the claim that he suffered a TBI. And that's supported by the defense.
There were certain rulings that excluded some of plaintiff's experts, correct?
There was plaintiff argues that Dr. Cicero was precluded from testifying as to TBI, whether he sustained a TBI, but she did testify.
So if the doctor is precluded from testifying about TBI, and then you want to argue that they failed to establish TBI, that kind of begs the question, no?
But the fact is that she was not precluded from testifying as to a TBI. She testified multiple times that she was treating the plaintiff for a TBI, but all of that testimony was rejected by this jury. And so if you view the facts in the light most favorable to the defendant, as the trial court did, this argument was raised before the trial court, and the trial court said this determination came down to a credibility determination, and the jury just simply did not believe plaintiff. And now plaintiff is trying to get another bite of the apple before a different jury, which should not be permitted.
Okay. Thank you.
Am I out of time?
You have any? No, you still have time, but you sounded like you were finished. You can continue, though.
I wanted to touch upon our appeal on the serious injury threshold. Plaintiff failed to meet the threshold because the pivotal piece of evidence that plaintiff's experts, none of them addressed, was plaintiff 6 weeks after the accident, plaintiff visited Dr. Schneider, a neurologist. And at that visit, he had no complaints of neck pain, no complaints of shoulder pain. The doctor performed a neurological examination. The plaintiff had full range of motion in his neck, and he had full strength in his upper extremities. The failure of the plaintiff's experts to address that contradictory evidence, they also failed to address significant gaps in treatment. That failure rendered them in the evidence insufficient to establish a serious injury. And with respect to the TBI, plaintiff did not submit any evidence from a doctor who actually diagnosed him with a TBI. The other doctors were referring to records that were never admitted into evidence. The only evidence of neuropsych testing that was admitted at this trial was by the defense, and it established that plaintiff was feigning his injury.
Well, what about the tests that were submitted by Dr. Cicero? It may not have been an MRI, but she did objective tests in her office. So why should not we, be able to consider those tests?
She did not perform any neuropsych testing. She only treated him for his claimed inability, his memory issues, and his claimed inability to work. She did not perform any neuropsych testing. Dr. Chavant, the life care planner, referred to neuropsych testing, but it was never admitted into evidence, and not a single expert testified as to what that neuropsych testing indicated.
Okay, thank you.
Thank you.
Ms. Rosen, you have 3 minutes.
Okay, Your Honors, before I address my adversary's arguments, I do want to get to the 50% fault because that's a big part of our appeal as well, which I wasn't able to address in my opening argument. The jury somehow assessed 50% fault against the plaintiff. I'm not sure I really understand. I can't even articulate how they could have gotten to that number. The bus driver admits that she didn't see the plaintiff after first seeing him. She had him in her view, then she lost him, and she didn't see him as a result of a blind spot. I mean, she admitted it to the police, and she admitted it at trial, although there was a recorded statement, and we did raise this in our papers, that the plaintiff tried to get an adverse inference charge at trial for the missing statement that she made to her employer, but she admittedly did not see him. So there's no evidence that he was not in the bike lane, that he was not operating his bicycle in the pedal mode, not the electric mode, and that he was going straight. We had Mr. Desch, who was an accident reconstructionist, that did a diagram and an animation after going to the site and doing the geometry of the site.
Wasn't there testimony that he may have been going too fast on that electric bicycle at the time of the accident?
Your Honor, the only testimony that's undisputed, because they didn't provide any testimony to challenge this, is that the plaintiff was going 12 to 14 miles an hour, and that he was in his bike mode. He was in the bike pedal mode. He was not in the electric mode. And that if he was in the electric mode, he would have been going 20 miles an hour, as opposed to 12 to 14. But more importantly, it still doesn't. So that's the testimony that's undisputed. But it doesn't change the fact that Ms. Posis admittedly made a right and didn't see him. So I don't know where the 50% comes, but that's significant. As you know, it drastically reduces any recovery he has. So in that regard, we would ask you to not only readjust the fault, but eliminate the 50% fault to the plaintiff, as there's absolutely no evidence that he had anything to do with this accident. It was admitted by the bus driver that she.
Counsel, you have less than a minute left.
Okay, so with regard to degeneration and pre-existing condition, I just want to point, I'll just give you the record sites so I don't lose all my time, but Dr. Sobel and Dr. Haar most absolutely addressed the issue of him not complaining at the beginning about any pain at the emergency room or within the first couple of weeks. This is in keeping with Pearl against Mayer, that injuries develop over time. Dr. Sobel is at 350 of the record. Dr. Parr is at 967 of the record. If you could take a look at that, please. And 386 to 387, Dr. Sobel also testifies with regard to degeneration that there isn't any, and that there's no question in his mind that the fact that he didn't initially have any complaints of pain to Dr. Schneider doesn't take away or mean that he didn't have this significant and severe tear and cervical herniations. One last thing before I close. Okay.
I'm gonna give you 30 seconds.
Okay, I just have one case which I think is really important. It's not a new case, but it's Godfrey against GE Capital from this court. It's 89 AD 3rd 471. It's a really interesting case on traumatic brain injury and how this court analyzed it. I mean, it happened to have awarded $2.5 million for the traumatic brain injury, but more important than the number is the reasoning and the way this court analyzed and viewed the traumatic impact of traumatic brain injury has to someone's life. So I'd like you to take a look at that case, please.
Thank you.
Thank you so much.
Solomon?
Yes, with respect to the apportionment, there's plenty of evidence in this record to support the 50% apportionment against the plaintiff. The plaintiff testified that he did not reduce his speed despite the fact that he was entering an intersection. His own expert testified at page 294 and 298 of the record that any biker
was this intersection controlled by a green light?
I believe it was, yes.
So then he doesn't have to slow down to go into an intersection unless he's turning.
Well, his own, I'm not positive.
If you're proceeding straight through an intersection, you don't have to slow down unless there are people in your way or you're making a turn.
Well, I'm not sure if it was a stop sign or a traffic signal, but
Can you address Ms. Rosen's statements that the plaintiff was at all times in the bike lane? And according to my read of the record, the bus driver says that she sees him in her mirror and then he passes her. She then passes him and she loses him and makes the right-hand turn and the collision occurs. And did I read that record correctly?
She said that she saw him before she made the turn. She said she saw him in the rearview mirror, but he was very far back, was her testimony.
Right, but did I get the facts right that she then says that he passes her after she sees him in the mirror? He passes her when she stops to pick someone up or drop someone off, and then passes him again just before the turn.
Well, I don't know that it was right before the turn. She passes him and then she sees him in the rearview mirror and she testified that he was way back, which then supports the
So you're saying I just want to be clear because I didn't see that in the record that she sees him in the mirror twice. I thought she saw him in the mirror. She stops to pick someone up. He keeps going and passes the bus. She then proceeds and passes him and then turns.
Right, but she did testify that when she did see him, he was way back, which supports the inference.
The first time, I'm talking about after he passes her and she then passes him again.
Yeah.
Right, after she passes him and before turning, she loses sight of him.
She said that she didn't see him. She lost sight of him when she was making the turn. But before she made the turn, she said she saw him in the rearview mirror way back, which supports the inference that the plaintiff was riding much faster than he claimed. The other thing is that, yes, plaintiff testified that he wasn't using the motorized option on the bicycle, but again, this case boiled down to credibility determinations. Plaintiff's credibility was called into question multiple times during this trial. So it was perfectly reasonable for the jury to conclude that he was using the motorized option on the bicycle, which would be in violation of the vehicle and traffic law. They also could have concluded that he tried to pass the bus when it was unsafe to do so, also in violation of the vehicle and traffic law. The jury was instructed that both the defendant driver and the plaintiff had a duty to see what was there to be seen. And the trial court, in denying plaintiff's post-trial motion, assumes that the jury followed that instruction and apportioned 50% fault against the plaintiff. That there's no basis in this record other than if you usurp the jury's credibility findings on all of these issues that plaintiff raises. If anything is disturbed on this jury's verdict, it would be usurping the jury's finding on credibility, because all of these issues boil down to the plaintiff's credibility, and the jury just simply did not believe him. And there's no legal basis to disturb the verdict in that regard.
Thank you.
Thank you.
Okay. 388 Realty Owner versus AmTrust International.
Good afternoon, Your Honors. Max Gershwire for AmTrust. The primary issue here is whether the subcontract between AmTrust's insured W5 and Plaintiff Tishman required W5 to include the plaintiffs as additional insureds on its liability insurance policy, which was required to trigger coverage for the plaintiffs under the AmTrust policy. As the parties do not dispute, the subcontract includes conflicting provisions related to this issue. The provision on which AmTrust relies, however, trumps the others because it is the only one that appears in Rider A to the contract, which begins with the following critical clause, quote, "Notwithstanding anything in the other contract documents to the contrary, all provisions of this addendum shall supersede any conflicting provisions of other documents." The insurance provision in that document in the rider says, quote, "In the event that an OSIP, meaning an owner-controlled insurance program, is implemented for the project, the contractor is not required to provide insurance. Since it's undisputed that an OSIP was implemented for the project, W5 was not required to provide insurance, including for the plaintiffs, even if it was required to obtain insurance for itself."
Where does it say that it doesn't have to provide insurance if it's not accepted into the OCIP?
There's nothing in that provision that that carves out an exception for contractors that are not enrolled.
So why should we read into this language that if you can't enroll in the OCIP, it's not addressed one way or the other? Why should we read that say that you have no obligation to insure?
You're absolutely correct, Your Honor. You shouldn't read anything into it. It's a plainly worded provision. It simply says, in the event that an OSIP is implemented for the project, which it was, the contractor, and this is a contract with W5, is not required to provide insurance. So I think, in other words, what I'm arguing is
you're on mute.
Am I right that W5 and Calvin were not enrolled because they were deemed to be ineligible to enroll because they were the demo contractor and subcontractor?
That's correct, Your Honor. That there was an exception in the manual, in the insurance manual for demolition contractors, and that would be why. Although I don't know that there's any admissible evidence in the record as to whether or not they were enrolled, but you're correct, Your Honor, that manual said that demolition contractors are not to be enrolled. But again, it comes back to the plain language of the contract. If the contract were to include an exception for contractors that were not enrolled.
Talk about the plain language of the contract. Man, this is hardly plain. I mean, if you could make this any more confusing, all these different interacting and conflicting provisions, I don't know how that would have been.
Well, I understand, Your Honor, but again, there is a clause in the rider, which is the document that we rely on, that makes it very clear, right? It says again, in the event, notwithstanding anything in the other contract documents to the contrary, all provisions of this addendum shall supersede any conflicting provisions. So while yes, there are conflicting provisions, that document makes it quite clear that you can ignore those to the extent that they conflict what's in this document. And that's the one and only insurance provision that's in that document, and that is the one that AmTrust relies on.
Doesn't the OCP and the manual provide that entities not enrolled in the OCIP are responsible for procuring and maintaining their own insurance?
Correct, Your Honor. And there's no, and our position is there's no inconsistency, at least to that extent, right? The contract can be read to require W5 to procure its own insurance, which it did. But by the same token, it's not required to provide insurance if an OCIP is procured, which is what happened.
Well, that's ridiculous. That's ridiculous. Why would you be required to obtain insurance but not provide it? That's the whole point of insurance.
Because, Your Honor,
if an incident or claim arises, there is insurance to cover it.
Correct,
and in
Your Honor.
this industry, it is just part and parcel of the way they do business. You and
Absolutely.
I both know that.
Judge, I agree 100%. And so we're not contending that the contract did not require everyone to be insured. It did, right? The question here is not whether the contract required that everybody get insurance. The question is whether the insurance that W5 was required to obtain was required to include the plaintiffs as additional insureds. The whole point of an OCIP is to provide a single policy that covers everybody.
I understand,
with certain exceptions.
Since the OCIP did not cover this particular subcontractor because of the kind of work they were doing, then there absolutely is purpose in their obtaining insurance. The same reason that there is for any project.
Again, Your Honor, I agree 100%. We're not disagreeing with that. We're saying that
no, your argument is, yes, we have to have it, but the insurers don't have to put it up when an incident occurs.
No, Your Honor. The question is whether the policy that W5 was required to procure had to include as additional insureds the plaintiffs. That's the question here. The question is not whether the contract required them to procure insurance. We're not contesting that. This all boils down to whether
doesn't the contract and all this, doesn't all the contracts here say that the subcontractors that are hired to work on this project have to procure insurance to cover the owner and the GC and the project manager, as is the case on every single construction project in New York State?
The contract did include those provisions, but it also included this other provision. The question is, if there's a conflict, so which one controls? And we're saying that the writer A controls because it has this language that says, to the extent there's any conflict, this contract document controls. And that document says that the contractor is not required to provide insurance. So the only way you have to be able to reasonably reconcile these seemingly conflicting provisions. And the only reasonable way to do so, we submit, is to say that yes, all subcontractors had to provide insurance, had to procure insurance. But if as here, there was an OCIP, the contractors did not have to include the plaintiffs as additional insurers. So that's the distinction. That's how these provisions can be reconciled.
Thank you. You'll have time on rebuttal.
Thanks, Judge.
Mr. Sands, we'll hear from you. You have 4 minutes.
Thank you, Your Honor. Your Honor, I would adopt your characterization that in some ways it is ridiculous that an entity such as Citibank would have brought a demolition contractor onto the job site with no expectation of being insured. Now, in fact, the court below said repeatedly that there was no ambiguity here. And there is an attempt to create one, to feign an ambiguity here. The reality is the OCIP agreement says the non-participants had to purchase insurance. There's an insurance rider, and the direct contract between Tishman and the appellant's named insured W5 Group DBA Waldorf Demolition states explicitly that they had to purchase insurance in favor of Citibank. And moreover, this attempt to create this distinction between named insureds and additional named insureds flies in the face of long-established case law in New York that additional named insureds have the same rights under a policy as named insureds. So, you know, in sum, it just wouldn't make any commercial sense. If you want to talk about the intent of the parties to bring a demolition contractor on this site that was providing no insurance to cover the owner and general contractor.
Okay. Any questions? All right. If you have nothing further, then we will hear from you, Mr. Gershwire.
Thanks, Judge. I just want to reemphasize very quickly here. Everybody, all the parties to this case have insurance. They have insurance that's covering them for this incident. The only question here is, do the plaintiffs get extra insurance under W5's policy? That's the issue here. So I just want to make sure that that's 100% clear. There's no issue here about whether someone's going uninsured. Everybody has insurance. The question is whether the contract required W5 to include the plaintiffs as additional insureds. And again, we contend that the provision the rider controls and says where an OSIP is procured, it's not necessary to do so. Again, that's a separate question from whether they're required to obtain their own insurance. Finally, I just wanted to say that even if this court were to conclude that the lower court properly found a tribal issue of fact as to whether the subcontractor required W5 to include plaintiffs as additional insureds, it should still modify the order to delete the declaration that AmTrust has a duty to defend the plaintiffs, because as the cases cited in our brief show, any such declaration is premature unless and until any ambiguity in that respect is resolved.
But even if there's any possibility that there might be a reason under which you might be found responsible to indemnify, we know that defense is much broader than indemnification. If there's any possibility, why would you not defend? Why would the court not direct that?
Yes, because when there's a question as to whether a party even qualifies as an insured, where there's a question as to whether the underlying contract required that coverage. This, in fact, this is the case that I argued before this court, the M&M case, M&M Realty case. And the court found that there was an issue of fact as to whether the underlying contract required additional insured coverage. And until that ambiguity was resolved, it would be premature to say that there was a duty to defend. So there's a distinction between qualifying in the first instance as an insured. If there's a question as to that, you can't find a duty to defend until that issue is resolved. So if you find the lower court was correct that that issue still has to be resolved, then it's premature to find a duty to defend.
Thank you.
Thanks, Judge.
Okay. Lynch versus City of New York. Mr. Smith, you have 10 minutes.
Thank you, Your Honor. I want to begin by making sure it's clear. There are two ways, in my view, to essentially the same result in this case. The first is through 4 statutes, which, although they're not light reading, they are, I think, quite clear once you finish reading them. And the other
you mean as opposed to those insurance provisions which aren't so quite clear? Is that it?
Maybe. I can't comment on the insurance case, Judge. I do think this one's. I do think these are clear. You have to read them. I admit you have to read them more than once, but they're clear. Yes. The other statute, the other route to the same result is 513C2. But I want to make clear that those are essentially alternatives. And I want to start with the four statutes, because on those statutes, I really don't think the city has much argument left in light of the Court of Appeals decision in the child care case, which eliminated the so-called exclusivity argument, the idea that you can only provide rights to Tier 3 members through Article 14, which is all over the defendant's brief, but it's squarely rejected in the child care case. So I'm going to try as concisely as I can to go through the 4 statutes, and I call them 4 because there are 5, but 2 are mirror images, so I'm going to call them 4. The first one is Section 43 of the Retirement Social Security Law. It says that any member of NISLRS, the state retirement system, any member can transfer his or her membership to the police pension fund and, quote, shall be deemed to have been a member of the system to which he or she is transferred. That's the police fund. During the entire period of membership service, credited to him or her in the system from which he or she has transferred. And that's Neisler's. So when you get full credit, that says you get full credit in the police fund for all your time in Neisler's if you transfer. The city's first argument, not putting aside any arguments on exclusivity, which I'm going to ignore because the Court of Appeals decided it. The city's first argument is that, oh, well, yes, the prior service in the state system is credited. It just doesn't count. And it doesn't count because it's civilian service, not uniformed police service. That is, I have many problems with that argument. For starters, where does it say that? Where in the statute does it say there's a distinction between civilian and uniformed service? It's a distinction that exists in other contexts, but not in this one. It's just not in there. The city just keeps saying it's there, but it's not. Secondly, why would the legislature go to all the trouble of saying the transferring employee shall be deemed to have been a member of the new system for the entire period in the old system, that long convoluted sentence I just read, when it doesn't do him any good, when he might as well not have been a member? Well, yeah, because it's civilian service, then it doesn't count. It's as though the legislature was setting some kind of trap for the unwary here. And I don't think the legislature should be deemed to have done that. And thirdly, if the city's argument had any merit at all, it has just as much merit for tier 2 employees as it does for tier 3 people, to police officers. But they don't apply it. It's undisputed they don't apply it to the tier 2 police officers, and they don't explain why. And that's a recurring theme, because it will come up again that if they had any merit to their argument, they'd be treating the tier 2 people the same way, but they're not. The city on section 43, the city makes another argument. It says there's a statute enacted in 2005 that is, I would say it is partially redundant of section 43, and therefore you have to toss out section 43. It can't mean what it says. They are right. There is a partially redundant statute from 2005. The 2005 statute said certain employees can transfer a certain time from both Neisler's, the city system, and Neisler's, the state system. And they didn't really have to say Neisler's because section 43 had already taken care of Neisler's. That sort of redundancy, to me, the surprise is that it doesn't happen more often in this labyrinth of pension statutes. It's very hard to keep them straight in your head, as possibly your honors are figuring out. But the fact that once the legislature may have, out of excess of caution, enacted a partially redundant statute doesn't mean you take the plain text of section 43 and throw it away. Section 43 says that you can transfer your time and you're deemed to have been a member of the new system for the time you were a member of the old system, and that's all we're asking for. And it applies to tier 3 just as much as tier 2. Next statute, section RSSL, section 645. That's a buyback statute. It says essentially, former members of some system other than the police fund can buy back their time that they had in that other fund and lost for some reason. And if you do that, you are, quote, or he or she is, quote, entitled to all the rights, benefits, and privileges to which he or she would have been entitled had his or her current membership begun on such original date of membership, which is a long way of saying you get the same rights now that you would have had if you'd been a police officer then. But the city says, no, no, no. They say all the rights, benefits, and privileges mean no rights, benefits, and privileges whatever, because the prior service wasn't uniform service, so it doesn't count. And again, I'm going to make the same responses for where does it say that? Where does it say non-uniform service doesn't count for this statute? Doesn't say that anywhere. Secondly, this is even more in a buyback statute where you're asking the employee to dip into his pocket. Why would they offer you a chance to spend your money on time that is no good to you, that you can't use? And thirdly, you heard this one before too, why doesn't the argument apply to tier 2 police officers? It is admitted, and Justice Chan pointed out, some former tier 3 officers have been reinstated, moved under 645, under this statute. They've been reinstated to tier 2. Well, how can they do that if non-uniform time doesn't count? Doesn't make sense. But the city's fine with that. They don't complain about that. And why? So, but if they can do that, if the tier 2, the formerly tier 3, now tier 2 officers can move tiers, why can't the people who stay in tier 3, and they're staying in tier 3, we're not challenging that, why can't they get credit toward their credit in time toward their pension, credit in money to enhance their pension for the time they buy back? And the city never ever answers that question at any point. On section 645, I even have another argument, which is the 2002 settlement resolved the issue because it applies to any person who's a member of the police pension fund and a member of the uniformed service of the New York Police Department. And under the child care case, you really just have to read that to mean what it says, and it includes tier 3 members. So any doubt that tier 3 is protected by 645 is gone. Okay, statute number 3, 513B. That's a purchase statute. And this, I admit, is as hard to read as anything I've ever seen, but there's a certain amount of agreement on what it means. It says a member shall be eligible to obtain retirement credit hereunder for previous service with a public employer. And although you won't find the word purchase in there, I think everyone, including the authors of the statute book, know it's a purchase statute because there's another statute that refers to purchase under 513. In other words, you can, purchase is distinct from buyback, is you can essentially purchase time that you never had that you might have had under some other circumstances, which don't press me too hard on what they are. But that's that's the idea of a purchase. Now here on this one, the city has a different argument. They say, well, 513, they go to 513C2. That's the one that Justice Chan talked about on the frozen in time theory. And she says, well, that says you get only the rights the tier 2 officers had in 1976. So 513B can't give them more than that. And that's completely wrong because 513B is the later statute, much later. It was passed in 2000. There was a 513B before, but this expanded it to include what is read as a purchase right. And 513C2 was passed way back in 1976. Now, the 1976 statute does use the word only. It says, I think the substance is we're giving you only these rights in 1976. It does not say these are the only rights tier 3 people ever have, and no legislature can ever give them any more. And if it did say that, it wouldn't work because you can't tie the hands of a future legislature. So, and that's all there is to the city's argument on that statute. I think the purchase statute, I think, is completely clear. Okay, now I come to the last pair, 2 virtually identical administrative code sections, which I said I would treat as a single statute. And they say that time in certain city job titles shall be deemed to be service in the police force for purpose of eligibility for benefits and to determine the amount of benefits under the police pension fund. That's pretty clear language. And indeed, it's very hard to say that uniform service doesn't count there because non-uniform service doesn't count because they say it does. The statutes say it does. The city's brief on this one relies almost entirely on their exclusivity theory. It doesn't count. They can't do it that way because it's not in Article 14. And that's exactly the argument the Court of Appeals rejected in the child care case. The city also has what I would, I won't characterize it to be impolite. They have another argument. And they say the administrative code sections can't mean what they say because they have a provision in them for adjusting contribution rates. And that can't apply to tier 3 people because tier 3 people have a fixed contribution rate. And the very simple answer to that is the adjustment provision is qualified by the words as may be necessary, and it's not necessary for tier 3 people, and that's all there is to that. So I think the 4 statutes all have to come out my way. When you're done reading them. And under the child care case, I really don't think there's much doubt about it. I will talk about 513C2 in a minute, but if I have the time, I want to touch very briefly on 2 other subjects. First, is this Article 78 or a declaratory judgment? I think the governor, all I'll say really is I think the governing authority is Zuckerman, which is at page 33 of my brief. I'm not sure I can totally harmonize every case in this area, but Zuckerman's the closest on its facts. Zuckerman is a case involving a procedure, an adopted policy that affected a great number of employees. I think they were supervising educational supervisors or something like that. And it's like this one. and the court said that's a declaratory judgment case. And I'm going to take 1 minute, if that, on the city's cross appeal. They're looking for a clarification. Justice Chan said there's nothing to clarify. My decision is clear. And on that, although I have disagreed with her, I said she's absolutely right. It is clear there's nothing to clarify. And such time as I have left, I'll talk about 513C2, which is, again, I want to remind the court.
You're going to have to do that on rebuttal, okay?
Okay, thank you.
All right. So, Mr. Moore, the floor is yours. You now have 10 minutes.
Thank you very much, Your Honor. And may it please the court, my name is John Moore, representing the City of New York and the New York City Police Pension Fund. The key question in this appeal is whether Tier 3 police members are able to claim credit for time not spent as police officers toward their minimum eligibility requirement.
Can we agree that this case rises or falls based on the statutory interpretation here?
Yes, that's absolutely right. And
okay,
that's why,
so why don't we go through those? And let's start with Section 43, which I think is probably the steepest hurdle for you to climb.
So if I may, so in answering that question, let me turn to Section 513C2 of the Retirement and Social Security Law. Because
okay, so I ask you to tell me why Section 43 doesn't apply and you go to another section.
That's right, Your Honor, because Section 513C2 both postdates Section 43, and so by plaintiff's theory would control over 43. And moreover, unlike Section 43,
I don't know that that's accurate, and I really strongly suggest you answer my question. Section 43, how is it that if your entire argument is that the subsequent statute somehow invalidates, strips away, cancels out Section 43, tell me how. So and what statutory language in Section 513C does that?
So it doesn't cancel Section 43. This is a point that I want to make broadly about many of the points that my adversary made. These statutes still exist, and they're still broadly applicable to 5 pension systems operated by the city and all the members therein, and all of the systems operated by the state. What Section 513C2 does is defines 4 Tier 3 police and fire members for a very specific subset, what can be counted as creditable service. And that creditable service is only that service which could be credited at the time in 1976 for police and fire service. And so Section 43, though remains broadly applicable to teachers, to New York City Law Department members, to members of the state system, it does not grant Tier 3 police members the right to credit non-police service toward their minimum eligibility retirement date. That date is determined by 513C2 by its plain terms. In order to interpret 513C2, it requires 2 steps. The first is looking at the statute, the statutory language itself, which says that only service that would be creditable to members of Tier 2 in 1976, only that service is able to be credited for Tier 3 members. So then the question becomes, what would have counted for police and fire members in 1976? And for that, you look to the administrative code, and the administrative code is clear and it's undisputed that at the time you had to serve in the police force. This is referring to Section B1815D of the 1976 Administrative Code, as well as B330.1. It has to be the minimum number of years in the police force. Again, this is undisputed. There's no doubt that the Administrative Code in 1976 required that the police service be credited for service in the police department as a member of the police force. So at that point, the statute was completely clear. And again, there's no dispute as to what 1976 was as the state of the law in 1976. So once you have that in place, then looking at Tier 3 members' retirement eligibility dates has to be credited for the time, those years have to come from time credited as police members. You can't bring in a service that's not as a police member by the plain terms of their statute. Now, the PBA has a theory that, well, it says 1976, but really what the legislature meant is December 1st, 2009. There is absolutely no support for that, certainly in the text of the statute. A provision, a date is as unambiguous a statutory term as can be imagined. And there's no support in the legislative history that they've ever cited. It's guesswork on their part. And that's not enough. Guesswork on the part of the PBA is not enough to override a clear statutory provision like a date. So then you get to the question of, well, so given that the statute is clear that for Tier 3 members, you look to 513C2, it says, after you do that two-step process, it says only police service can be credited toward police retirement date. So then we get into the question of, well, what about all these other statutes that the PBA cites? The PBA says that there's no more, that anything can apply to Tier 3 members, that it doesn't matter if it's outside Article 14, but what they fail to grapple with is the actual decision that the Court of Appeals rendered in the previous case and the terms of 519.1. Section 519.1 says that outside transfer, retirement, reinstatement, that those provisions can be incorporated from outside of Article 14 unless inconsistent with the terms of Article 14. And what they're asking for this court to do is take 43, take 645, take the administrative code, and apply them in a way that is inconsistent with the plain terms of 513C2. Now, they've never addressed this point in their briefing, and it's not a point that the Court of Appeals addressed. In fact, as we've set forth in our supplemental brief, the Court of Appeals was clear that there was no inconsistency in that case. The court did not rule that 519 allows for any provision to override any, from outside of Article 14, to override any provision within Article 14. If that were true, 519 would serve no purpose whatsoever. The language, unless inconsistent herewith, would have no effect at all. That's not the way statutory interpretation works. The exclusivity argument remains in place for contradictory terms. And so where we have a clear answer in 513C2, and where the other statutes don't even apply to Tier 3 members if read the way the PBA would like them to be read, then that is essentially the end of the case. Even if we move on from that point, even if we say, well, 519.1 is a dead letter, it doesn't mean what it says, it means unless inconsistent herewith, or if inconsistent herewith, then you have to look at what the terms actually provide. And so Section 43, as I said, provides for you can credit service, but it's counted as it would be counted in the previous system, which is not police service. You don't get police credit for non-police service in the state system. And the same thing with 645. If a member joins the police pension fund today and had previously been a member in 2012, they can buy back time spent as a teacher or whatever else from 2012, have that, should they so choose. But granting them all of the rights, benefits, and privileges that they would have had in 2012 doesn't grant them the right to count non-police service as police service. Because Section 5...
This is Justice Kennedy, and I'd like to go back to Section 43, because we all agree that this is really an issue of statutory interpretation. Am I correct about that, Mr. Moore?
Absolutely, Your Honor.
So if that's the case, let's just look at the language of Section 43, because it says any member. There is no limitation. The only limitation refers to the hospital retirement system. Doesn't say anything about police, doesn't say anything about fighters, and certainly the Court of Appeals last year in Lynch said there was a different section, but it also had those same words, any member. And it says any member can only mean what it says. There's no limitation here.
So the decision, if I may, Your Honor, the decision in Lynch said that any member gets it so that it presumptively applies. And then because there was no conflict, it applied in that case. Here there is a conflict with Section 513C2. Now I'm sure that Mr. Smith will disagree, will point out where he disagrees with me in his rebuttal time. But in Section 513C2, you have both a later provision and a more specific provision. 513C2 was enacted after Section 43. Moreover, it applies specifically to Tier 3 police and fire members. That's a very limited subset, as opposed to any member, which, as Your Honor points out, applies very broadly. So where you have a later, more specific provision, by any method of statutory interpretation, that is the provision that controls. And so that's the provision that controls here. And so this very excessively broad reading that the PBA urges is contradicted by the terms of Article 14 by 513C2. The same reason applies to 645, same reason applies to the administrative code. 513B at least is within Article 14, so that's one that doesn't fall, that the court is at least, we're talking about it. It's in the ballpark. The problem with the PBA's reading is that if it means what the PBA says, then 513C2 has no effect. Indeed, that's the case if we take their reading of any of these.
Perhaps the council, perhaps that was by design. So if the police and fire under the older statute, Section 645, had these rights, and Section 513, as you argue, now restricts those rights. Perhaps 645 was the equalizer to give the police and fire an opportunity to purchase back some of that time in order to make do. Why is that not an equally reasonable understanding of 645?
What your honor is asking is whether the legislature engaged in repeal by implication, where rather than repeal 513.
Well, you're saying the same thing with 513C, aren't you?
No,
because
no.
if Section 645 gave the police and fire the rights they're seeking, and you say that by 513 being a specific statute, that by implication basically repealed the applicability of 645 for police and fire. No, is that not what you're saying?
So repeal by implication would repeal the entire statute. What I'm saying is that the legislature is able to carve out narrower provisions from general provisions. That's the interaction between 645 and 513C2. 645 remains applicable to Tier 2 members who aren't subject of Section 513C2. It remains applicable to members who aren't police or fire members. There's only this narrow carve out for Tier 3 police and fire members. And so the PBA's argument that the city has no response for this, the city has no response for that, often, Your Honor, the response is 513C2. It applies only to Tier 3 police and fire members. That distinguishes this from Tier 2 members. That distinguishes this from non-police fire members, all of whom are able to claim the benefits of Section 43, able to claim the benefits of the administrative code of Section 645. All of that remains in place. But 513C2, which my adversary said he was going to get to, but couldn't quite bring himself to do during the time allotted, is what answers almost every one of those points, and it answers it in favor of the city. If I may touch briefly on the cross appeal, because I see I'm running short on time, and I don't want to let that
I'm going to allow you another minute since I granted Mr. Smith an additional.
I appreciate that, Your Honor. There's no actual dispute that I can glean from the briefing that the benefits that could be read into Supreme Court's order are not ones that have any basis in the text of the statutes or are not what the PBA sought in this litigation. I understand that Judge Chan believed that her order was clear to the extent that this court is able, there's no harm then in the court saying that the benefits that are granted, regardless of which way the court rules on them, are limited towards the calculating the minimum eligibility requirements. There's no harm in doing that either to the PBA's position or ours, regardless of who wins. That clarification would remain valid and helpful to avoid the possibility of confusion that was demonstrated in the PBA's reply brief and that future litigation could result from.
What was the enactment year of 513C?
1976, Your Honor.
1976.
Yes, it was.
So So if wasn't 645 enacted much later?
Yes, that's true, Your Honor. But
so how does 513C, a specific statute which predates 645, I don't understand the argument that 645 then, by its plain language, doesn't apply to the police and fire.
2 points on that, Your Honor. The first is that 519 says that inconsistent provisions from outside of Article 14 don't apply to Tier 3 members. So you don't even bring 645 into it.
Except that 645 didn't apply at the time it was enacted. So you're saying that that language, no matter what gets enacted later, controls?
I'm saying that the legislature doesn't legislate on a blank slate. And so I agree with the PBA that should the legislature have intended to override 519, it could have done so. There would have been no limitation.
But it's not even an override issue. I don't see them necessarily as again, if 640, I want to make sure I get the numbers right. Hold on.
I've got my cheat sheet available too, Your Honor.
I had to look. You gentlemen have been playing around with this for a lot longer than we have. So the section 43, which predated 519, right? So I can certainly see your argument there because 519 comes later. But I'm grappling with the argument that the legislature, which we can assume was aware about 519, nonetheless enacted this statute and did not restrict the police from being a part of it. What do you say about that?
So at this point, so what we're talking about is repealing all of 519 by implication. We're talking about repealing 513C2 by implication, so that there's nothing left of 513C2, which would be a very curious way to go about doing that by enacting a completely different provision. Moreover, to Your Honor's point about there being specific and later, there's also precedent from the Court of Appeals, for instance, Dutchess County Department of Social Services versus Day, that's 96 New York 2nd 149, which says, and similarly from the U.S. Supreme Court, to the extent that this court is influenced by that, Morton versus Mancari, 417 U.S. 535, both of these are in our brief, that say that a more specific provision controls. Full stop. It doesn't say anything about more specific and later. More specific and later by any stretch of the imagination controls, but even simply a more specific statute is enough. And that's what we have here with 513C2.
All right. Thank you.
Thank you very much, Your Honor.
Mr. Smith, you have 3 minutes. Unmute yourself, please.
Thank you. I think I'll do much better when I'm not on mute. Section 43, Mr. Moore made an argument I don't think I've heard before, in which he says, oh, well, Section 43, it couldn't mean anything because of the limitations in the administrative code. That's a complete mishmash, because Section 43 talks about transfers from NICELRs, the state system, and the administrative code, as you would expect in the city administrative code, is talking about certain titles in NICERS, the city system, and they just don't have anything to do with each other, and there's just nothing to that argument.
Could you address your adversary's arguments with regard to 519C3, which I interrupted you and prevented you from going into last time? I think that
Your Honor, I think you mean 513C2, although I admit it's very easy.
Yes, that's the one.
Yeah. He said it once, he said it 10 times and another 10 times in his brief that 513C2 is inconsistent with all these other statutes. But he never quotes the inconsistent words because they aren't there. There is no inconsistency. 513C2 says, as read by Supreme Court, and for the sake of the argument, for most of my argument, I assume Justice Chan was right, says we're giving you all the rights that you had, we give as to prior service, we give police officers all the rights that police officers had in 1976. That includes Section 43, because Section 43 was there in 1976. Now it does have the word only in it. They have only those rights. But that word only seems to be the word, the read that Mr. Moore is relying on to say all these other statutes can't possibly apply to police officers. Well, of course they can. And if they didn't mean to apply to police officers, why don't they say except for police officers? Or why? And there's a way of the authors of the statute have a way of distinguishing between, I think it's uniformed and general members. But they say any member. These things apply broadly to members, not just to non-uniformed or general members. So there's no, The later statutes are quite clear, and there's no basis for saying inconsistency. And I really admire Mr. Moore's courage for trying to stick up for the exclusivity theory after what I thought the Court of Appeals did to it in the child care case. Yes, if there is an inconsistency, the later statute prevails. And certainly, if you can make a theory that if you're trying to resolve a conflict, you pick the more specific. There's no way that 513C2 is specific in that sense. The later statutes are much more specific. They apply to very specific things. These people can buy back these time. These people can purchase this time. These titles' time shall be counted toward police service. It just isn't there. Finally, on the 519, Your Honor, is a different story. That's also pretty well taken care of in the Child Care Act case. I think it's sufficient for me to say there's absolutely nothing in 519 that gives any support to what he's saying. And if you have any doubt about that, the Child Care Act case should eliminate it. Finally, on the cross appeal, he said there's no dispute as to what these things mean. There is dispute. He's wrong. We make it very clear in our brief. He says that I guess it's the administrative code sections, but by implication, everything else applies only to times, to credit for time in the sense of time toward the pension and not toward enhancement of benefits. There's no basis for that. It's completely made up. It counts for both of them. It's clear from Justice Chan's opinion. She's right about it. It should not be modified. And this is not a mere abstract dispute. It's a substantive point and an important one. And I believe I've covered what I wanted to cover. Thank you, Your Honor.
Thank you so much. Thank you both. Okay, Universal Construction versus NYCHA.
Good afternoon, Your Honor. Thank you very much for hosting this argument today. May it please the court, my name is Gil Namias, arguing for New York City Housing Authority, appellant in 3 cases before this court that were decided by Justice Margaret Chan. The issues before the court are not novel issues. Just over a year and a few months ago, this court decided Universal Construction, Inc. versus New York City Housing Authority, very much a companion case to the 3 cases that are before it today. And in that decision, this court reversed the judgment of Justice John Kelly, which at that time had determined that the Housing Authority's motion to dismiss would be denied because there were issues of fact as to when the claims of the plaintiff Universal Construction had arisen. In determining that the decision should be reversed, this court determined that Section 23 of the New York City Housing Authority's general conditions, which is the notice of claim provision, a provision that requires all claims raised by contractors in doing work for NYCHA be raised within 20 days when the claims arise, at the very latest, arose upon substantial completion or final acceptance of the construction project. In these 3 cases, the Housing Authority, and I'll say painstakingly showed for each of the claims raised by plaintiff Universal, actually arose at various stages throughout the construction projects. But putting that aside, at the very latest here, each of the contracts, substantial completion occurred October 30th, 2015, December 28, 2016, and June 29, 2016. Each of the applicable notices of claims filed by Universal Construction were either several months or almost a year after substantial completion was achieved on these projects.
And at the end of the day, that is the bottom line issue, right? Hello? I think you're frozen. Or is it my computer?
No.
Oh boy.
Okay.
Yours.
There you go. Okay, we got you back.
I'm sorry. Okay. Well, this technology is a challenge for all of us, I suppose.
Yes, it is.
Yeah, Universal did raise that issues that they purportedly had served some notices of claim before the ones that were issued. They raised that in their complaint. However, as this court has determined on many times before, the requirement for Section 23 is that a notice be designated a notice of claim, state the nature and basis of the claim, and also state the damages.
Well,
as we noted,
didn't the contractor allege in numerous of these situations that it just was not possible for them to figure out the exact amount of damages, and they gave you the information, but it was almost impossible to do. I mean, I was on that last bench, and I see that even defendants' alleged misconduct is not supposed to, take away their obligation to fulfill sections 23 of the contract. But don't they say that kind of repeatedly throughout these three appeals?
Well, I think I would make several notes on that, Your Honor. As was dealt with in the Universal case, first and foremost, as Universal did its job, it was required to pay its laborers and keep track of the records on a weekly basis. It purchased materials and equipment prior to doing the work, and its overhead and profit were based upon a generic formula that they used in their calculations. That was evident in their notices of claim. So throughout the course of the work, they were very much aware of their costs and what they were entitled to. What they usually refer to as impossible to determine is they base the argument that, well, they were in continuous negotiation.
Whoops, we lost you again.
With the house. Oh boy. Hello?
Yeah, we
now
got
we hear you.
Okay. So I'll make it short. Basically, what they were alleging was that there were ongoing negotiations trying to resolve the dispute of what they claimed they were owed. However, first and foremost, the very fact that they're negotiating very much shows that they were aware of their damages. So they had clearly ascertained their damages prior to when they said they could only do it upon final payment. More than anything, this court has also determined in SJ Fuel as well as High Tech, negotiations, whether they be settlement negotiations or even awareness of the claims, do not excuse the failure to satisfy the condition precedent of Section 23. If you do not comply strictly with the requirements of Section 23, contractors' claims are waived. And here, the failure to do that requires that these claims be dismissed as the Housing Authority moved to do so below. I think for the moment, then I will rest on that, reserving my time for a rebuttal.
Okay, thank you. All right, Mr. Marco. Mr. Marco?
Uh-oh.
I hope we haven't lost him. Let me check. Mr. Marco, if you are with us, we can't hear you.
Can you hear me?
Now we can, yes.
Oh, sorry. There was some sort of message before that put me on mute. It's very confusing, but anyway. I would like to start with the argument as to the triggering of the notice of claim issue. I think the Court of Appeals is pretty clear that it's not always substantial completion. It's not always when a contractor submits a final invoice. It really has to be taken on a case-by-case basis. So the main issue, I think, in all these cases is when did UCR's damages become ascertainable? Let's take Roosevelt, the project, for example. I believe that there's credible evidence in the record that on this project, their damages did not become ascertainable until NYCHA issued a final quantities list of its unit price work, which was sometime in April 2017. Now, I think it's important to point out that a unit price contract is unique in that a contractor will not really know its damages.
Wasn't the job already finished by April 2017?
Sure, it was, but
So
but
I don't
we have to go-
understand. This is a typical unit per unit contract, I believe they call it, correct?
Correct. It's correct. So how this works is when the job is originally awarded to the contractor, NYCHA will have an estimated amount of quantities at a unit
No, I
price.
get that. You don't have to go over that. Trust me, sir. We see enough of these cases that we understand the world you are in. What I don't understand is why you claim that it took 4 months after the project is over to come up with a number and to be able to describe what the claim was.
Well, because on the Roosevelt project, the record indicates that NYCHA was actually controlling the payment process on that project, not the contractor. So it's unique in that respect. So, for example, during the project, NYCHA was basically manipulating the various line items for unit price work and deciding how much would be paid for each quantity, and it didn't have anything to do with the actual work performed. And they would always assure the contractor, don't worry, at the end, we'll reconcile everything. NYCHA didn't reconcile everything until April 2017, when they actually sent the contractor what's known as the final invoice. I actually urged the court to look at the Carthage case in the 4th Department, which I believe is similar, where the record there reflected constant adjustments and changes in the work, which were not finalized until the end of the project by the owner's architect. And it was at that time that the court found that the contractor was able to quantify his damages. I can just give you a quick example. There was a line item in the contract for vertical expansion joint work. There's no way for UCR to know if it's been damaged and in what amount until NYCHA, at the end, when it issues the final reconciliation, informs them of what's been approved, the quantity that's been approved. Up until that time, they simply don't know, and anything that they submit would be an estimate. It wouldn't really be accurate.
So wait, on that point, are you saying that if your client submits a notice of claim and projects out what they believe at that moment, what that damage will be, and later during the process of reconciliation, your client feels like they need to amend that number based on what the city says, you are not allowed to do that under the contract?
No, of course not. I would think you would be able to amend, but really what I'm saying is
but then that begs the question, sir. If you can amend your notice of claim, then there is no excuse for not preserving your right under Section 23. I get it. It may not be needed. It may force your company to do work twice, but at least you've preserved your claim.
But there's still the issue of, has a damage even occurred? If the contractor doesn't know what's the quantity the final quantity that's been adjusted for a line item, he doesn't even know at that time if he's been damaged.
Counsel,
I think that's part of the problem.
Counsel, here you have repeated instances where, and this is not an unusual situation on city contracts, that the contractors are bombarded with repeated and constant change orders. This happens on every city contract. We haven't had not one case like this where that's not the case. So this is completely foreseeable, and the contract language is clear.
I understand, Your Honor. I would like to discuss another issue which I feel affects two of these projects and possibly the third, and that is NYCHA's acceptance of UCR's conditional release, which I believe raises an issue as to whether they raise compliance with Section 23. If going back to the Roosevelt project, for instance, if you would recall, the record seems to show that NYCHA's chief of commercial litigation negotiated a release with UCR, which specifically reserved UCR's claims, which were set forth in the April 2017 notice of claim. That NYCHA obviously claims is untimely. Now, they accepted
did that notice of claim say it was a notice of claim as required under Section 23?
Yes, it absolutely did. It was verified. It went beyond what was required. But I think what's important here is that, number one, the release was actually negotiated between NYCHA's chief of commercial litigation and UCR, and it was negotiated apparently to resolve a dispute over what the final reconciliation of the contract was, which they were disputing a month prior in March. Now, the release that's drafted, and
so
and
are you saying, are you saying, counsel, that the release waived your obligation, or that it waived the obligation to have put this in time because the release superseded it, so to speak?
Well, I believe that it raises an issue as to whether NYCHA waived compliance with Section 23. Yes, and another reason is because if you read the release, which I believe that NYCHA had a hand in drafting, it makes no reference to Section 23 as being a bar to any claims. If they intended that to be a bar, they could have simply inserted it, but they did not.
Or they leave it out and hope that your lawyers sleep. I mean, there's two ways of reading that. They could have been very clear that that this agreement did not waive Section 23, but is there any language in the contract that permits for waiver of Section 23 absent an affirmative statement by the city?
Well, I think waiver in itself is always an issue. I understand that NYCHA has no estoppel provision in the contract, but there are several lower court cases, for example, that have dealt with the waiver issue under Section 23 and found that it's not an indestructible provision, the no estoppel provision. There still can be instances where NYCHA may have waived compliance with Section 23. And again, because NYCHA drafted, or it appeared to draft and negotiate this release, and the release specifically refers to the claims that NYCHA is trying to dismiss now. That's what was reserved. Now, once they accepted that release, they made final payment because that's what the release was for. And final payment then triggered another contract section. And that contract section says that once the contractor accepts final payment, they are releasing NYCHA from all claims except those expressly reserved, which are the ones set forth in the conditional release. So I think that alone should preclude dismissing all of these projects. Now, the conditional release is not in the record on one of these projects, the Lafayette project, but I would suggest that that's a reason that discovery should be allowed on that case, because these are all sister projects, and really, quite frankly, I find it hard to believe that the same conditional release that's on the other two isn't present there.
Thank you. Thank you. Okay, Mr. Jaimes, you have 3 minutes.
Okay, let's hope I don't freeze on this one. I'm going to I'm going to focus on the conditional release argument. And first and foremost, a conditional release is a form that's filled out at the end of virtually every NYCHA contract. And what that is essentially is, in exchange for the final payment, they issue a release, but in order to avoid, to be able to close out the contract, they will often accept claims which they refuse to release. Here, what you have is you have an interplay here. Section 23 has already required that these claims are waived. They cannot revive an already waived claim by simply sticking it in the release. Second of all,
except that here, on on the 4/27/17 notice of claim, it's only late by 16 days as I read it. And if that's the case, then is there an argument to be made that the negotiations leading up to that were being considered in light of the impending deadline?
No.
Or am I wrong on the deadline?
No, Your Honor, I'm not sure which notice of claim you're referencing, but I would just still focus on the fact that what you're talking about is the release signed by.
Claim. On
Okay,
the Roosevelt
claim, there is, right. Their notice of claim was filed May 2nd, 2017. The final release came after that.
There was an April 27th notice of claim. Are you saying that was not an adequate one? It wasn't delineated as such?
No. The April, and that's sorry, that was actually received May 2nd, 2017. It's dated April 27th.
Okay.
But the point I would make to that is that the general release is not a document that was signed by NYCHA. There is no indication of any waiver of the contract provisions, nor would anything as such could be construed. Under the contract, Section 62, which is the no waiver estoppel clause of the contract, says that no act or action of any NYCHA employee can waive any provision of the contract unless there is authorization by NYCHA's board, by a resolution expressly waiving that provision. Here, there is no issue of fact. There was no such resolution. So no matter what the claims are in respect to negotiations, there was no waiver of Section 23. And by that point, the claims that they claim are preserved by the release actually had already been waived. And you can just not revive any claims by just sticking them in a release. There was no such agreement by any party that NYCHA would waive that. There's nothing of that in writing. So therefore, it's really not an argument of any merit. Section 23 is clear, explicit, that the claims, in order to be preserved, must be filed within 20 days of the time they arise. You must have specific contents of it. It must be designated notice of claim. You must include the damages. You must include the nature of the basis of the claim. Here, it's clear on its face. There can be no dispute that by the time of substantial completion, all the claims raised here had been arisen, and the failure to file a notice of claim within 20 days of those claims requires that those claims be waived, and the judgments below or decisions below should be reversed, granting NYCHA's motion to dismiss all those claims.
Thank you.
Thank you, Your Honors.
Have a good day. U.S. Bank versus Bakhtor. Mr. Froelich, you have 4 minutes.
Thank you, Your Honor. Hopefully you all can hear me.
Yes.
Excellent. Last but not least, certainly. My name is Joseph Froelich on behalf of U.S. Bank, and to please the court. This case has some very unique facts, and really all of those facts taken together really should have prevented the trial court from granting summary judgment to the borrowers in this case. First big unique fact, the borrowers signed a statement of intent reaffirming the debt down in a Texas bankruptcy so they could keep their $1 million rental property up in a Trump property up here in New York. You also had the borrowers signed a trial payment plan. And then on top of that, they made the payments under that trial payment plan, making partial payments that at some point
that wasn't exactly ironclad. They were attempting to get a modification, right? And they had to participate in this.
They tried.
If I could finish, that would be helpful. So they had to make 3 payments before there would be a modification. So there wasn't yet a modification that was in place, correct?
Absolutely, Your Honor. But they did make.
Which means it wasn't reaffirmed then.
Well, I think you're confusing things, Your Honor.
I don't think I'm confusing anything, but I'll let you argue. Go ahead.
Sure. The reaffirmation occurs in the bankruptcy court. They signed a very specific document entitled a statement of
Yes, that was in 2011, right?
Absolutely. They signed that document.
So that's a little stale, so we have to move a little further up, which is wwhy you began arguing about the modification.
Well, let me get right to that point then, Your Honor, which the trial court found that reaffirmation found that was a under our general obligations law 17-101, that was something that would restart the statute of limitations, right? The trial court made the mistake where it immediately started the statute of limitations as soon as the bankruptcy ended. What the trial court should have done was the trial court should have looked at our very established New York law and said, what is the trigger point to restart that statute of limitations? And the law in our state is very clear. There's 3 trigger points in an installment loan like this. You either have to have a clear and unequivocal notice to the borrower that you're accelerating. You have to have either an obligation to make the payment under a balloon payment, and I don't think that one applies. And then the third one is either you have to commence a foreclosure. And our position here, quite frankly, is that the triggering point would have been the commencement of the second foreclosure, which occurred back in, and I will get that date here on, in 2013. And if that is the trigger point, then when we file in 2017, we're golden. We're still good. That's our argument in a nutshell, Your Honor. And the arguments made by the respondents here are in essence, well, there was a prior foreclosure that was still pending. But if you look at the record, that foreclosure, nothing happened in that foreclosure. And at a minimum, that should have created an issue of fact that the court should have said, okay, if there is a question of what occurred in this foreclosure, would that act to re-trigger the statute of limitations? That should have been an issue of fact. We could have had discovery on what occurred in that case. We could have moved forward. At the end of the day, that didn't occur because they stonewalled us on the discovery. And then at the end of the day, didn't give us the documents. And then when we were supposed to depose them to find out what was your intention when you made these partial payments, we never got to ask those questions. And that's an important point, Your Honor. Our argument, both on the reaffirmation, is somewhat separate from the partial payments. New York law is very clear that partial payments also can restart the statute of limitations. So while I think our best argument is certainly the one dealing with the reaffirmation down in Texas, I think the fact that they made the partial payments is another basis in which we should have received discovery, because part of the basis with partial payments.
You're calling the trial period payment plan as partial payments.
Two different things.
There was no agreement yet to allow this mortgagor to satisfy yet. He had to complete this process first and then submit it for approval of a loan modification, which would have restarted the entire obligation all over again.
You're absolutely right. If they would have signed a modification that would have started the statute all over again, this would have been an easy case. I wouldn't be here right now.
But now, I have
a
question, Mr. Fuller. So one of your arguments is, if I understand it correctly, that the commencement of the second foreclosure action in October 2013 started the statute of limitations running again because you accelerated. Is that what you're saying? Because you accelerated at that time?
Yes, Your Honor.
And now, I'm sure you're aware of the fact that recently in the court, I think last month in the Court of Appeals, there were several cases that were argued, the Vargas case and whatever, about what constitutes an acceleration, because the different departments, it's come out a lot of different ways. Am I correct?
Sure, Judge Catton. And I was planning to start with that, and I easily got derailed. So I think, quite frankly, it's the Engel case, which was argued on January 5th. Right. And I actually watched that argument.
Me too.
And as you all would know, trying to read the tea leaves of what the questions of the judge are and what the decision will be is probably a fool's errand. But having watched that, I think there is at least a toss-up chance that decision will be dispositive of this case. Meaning, if it is determined in that case that the filing of a stipulation of discontinuance acts as the affirmative act of deceleration, then in this case, when they filed the stipulation of discontinuance at the end of the first foreclosure, that would have stopped the statute of limitations. Statute of limitations would have started again when they filed the second foreclosure, and again, we would still be fine. So I do think that this court probably needs to see what happens in Engel. I think it can be dispositive of and be favorable for me. But if it's not favorable, it still have the.
When do you believe the statute of limitations commences to run against your client again?
Well, I believe it started to commence to run against my client when they filed the second foreclosure action on 10/15 of 2013, and this action was filed on 11/1/17. So we would be within the 6 years of that period.
Okay. All right. Any other questions?
No, thank you very much.
Thank you so much.
Thank you so much, Your Honors. I appreciate this. My wife got to see a beautiful courtroom.
Thank you. Have a good
wish we
day.
could see it.
And this
Thank you,
concludes the session of the Appellate Division, First Department. Thank you and good night.